Madam, the Criminal Law Temporary Provisions Act, or CLTPA, was enacted on 21st October 1955. The Act was last extended by Parliament in February 2009, and it will expire on 20th October 2014. This bill seeks to extend the Act for a further 5 years with effect from 21st October 2014. Madam, the Act was first promulgated in 1955 to address the serious threat posed by communism and secret societies. The powers for detention and supervision of persons were then introduced in 1958 to fight gangsterism and secret societies. Eyewitnesses were too afraid to testify in open court against the secret society members for fear of reprisals against themselves and their family members. Over time, the powers under the Act have been invoked in response to new criminal threats that have emerged. For example, in the 1970s, the activities of drug trafficking syndicates became a serious issue that required a swift response. In the past decade, unlicensed money-lending syndicates became a concern with their brazen harassment tactics. These crimes posed serious threats to public order and safety, with the same difficulty in securing witness testimony in open court. Madam, this evolving criminal threat is the reason we cannot let our guard down, even though our crime rates have fallen for several years. The threat to public order and safety is clear and present, although it may manifest itself in new and different forms. Hence, the CLTPA continues to be a critical part of our criminal justice system, allowing law enforcement agencies to act swiftly and decisively against criminal syndicates. Madam, let me illustrate with specific examples the nature of the various threats that we continue to face today and how the Act has been effective in addressing them. While secret society activities have abated somewhat since the 1950s and 1960s, the threat has by no means been eradicated. Each year since 2009, there has been an average of about 75 reported fights involving secret society members. These incidents have ranged from minor skirmishes to larger fights and confrontations involving more gang members. Most of those involved in such incidents have been dealt with in court. However, in some instances, the powers under the Act were used as our enforcement agencies had to act decisively against such gangs and their activities that undermined public safety, peace, and good order. Take, for example, the widely publicized case in Bukit Panjang in November 2010. Armed with deadly weapons such as parangs and choppers, gang members planned a retaliatory attack against a rival gang and relentlessly searched for them in the Bukit Panjang housing estate. As a result, 7 victims, including innocent bystanders, were seriously injured, sustaining multiple slash wounds, cuts, and lacerations. Such gang activities cause alarm and fear within the community and wider public. It was not possible to prosecute the perpetrators of this egregious and violent attack as the witnesses were unwilling to testify against their assailants in court for fear of the consequences. Eventually, 6 perpetrators were detained under the Act, another 3 were placed on police supervision, while 5 others were given stern warnings. Without the powers under the Act, these perpetrators may not have been brought to justice. We need to send a strong, deterrent message to those who have no qualms in using violence and in committing such crimes. Let me move on to drug trafficking. While the overall situation is under control, drug trafficking continues to be a challenge in Singapore. CNB's enforcement efforts saw a record seizure of drugs in 2012, with an estimated street value of 18.3 million Sing dollars, a 14% increase from 2011. Regional developments compound these challenges. The production of opiates in the Golden Triangle has continued to increase in recent years, alongside a rise in heroin seizures in regional countries. At the same time, transnational drug syndicates from Africa and the Middle East continue to bring ice and other illicit drugs into the region, drawn by the rising affluence. Our regional connectivity has also prompted drug syndicates to attempt to route their drug consignments through Singapore. One example was a West African syndicate, which was based in Singapore and actively recruited Singaporean women as drug runners. The members of this syndicate would prey on Singaporean women through internet chat rooms and night spots and lure them with offers of high-paying jobs and overseas travel. Even though recruitment and coordination occurred in Singapore, the drugs were physically handled overseas. In view of the absence of drug exhibits seized in Singapore to enable a court prosecution, as well as the witnesses' refusal to testify in open court, 2 Nigerians who were part of the syndicate were detained under the CLTPA in 2009. The syndicate shifted its operations to other countries after CNB moved in. Again, it would not have been possible to dismantle the syndicate's operations in Singapore without the CLTPA. The Act has also been used to deal with some cases of unlicensed money lending. While the overall number of reported unlicensed money lending and associated harassment cases has declined by 40% from 2009, it remains an area that police is actively tackling. In recent years, the tactics of such syndicates have also evolved. For instance, they have moved parts of their operations overseas to escape detection, employed debtors as runners, or used bank accounts registered by debtors to preserve anonymity. In 2009, the CLTPA was used to detain a tauke of a UML syndicate operating in Singapore. In that role, he was responsible for the formation and financing of new UML stalls and the recruitment of syndicate members. He directed his runners to harass defaulters. The syndicate vandalized public places, splashed paint, and scribbled UML messages on walls. Overall, the syndicate was responsible for over 500 harassment incidents and even shifted some of its operations overseas to evade detection by the police. Members would agree that we must come down hard on such syndicates, especially those who are in the upper echelons, who have removed themselves from the day-to-day operations and hide behind complex and layered syndicate hierarchies. More recently, in October 2013, the CLTPA was used to deal with 5 persons for their involvement in global soccer match-fixing activities. Of these, 4 were issued detention orders and 1 was issued a police supervision order. The underlying nature of these match-fixing activities is no different to those of other criminal activities that have necessitated the use of the Act. Such criminal activities are often carried out by organized syndicates with complex and layered structures and extensive networks which make full use of technology. Also, where cross-border illegal activities are involved, the difficulties of securing witnesses who are willing to cooperate and testify in open court are amplified. Madam, as at 31st October 2013, there were 209 criminal law detainees. This is a decrease of about 36% from the 326 as at 31st December 2009, the year the Act was last extended. Of these 209, about two-thirds were detained for secret society-related activities, a quarter for unlicensed money lending, and the rest for drug trafficking and other syndicated crimes. An average of 43 detention orders were issued each year between 2008 and 2012. The number of detention orders issued annually has decreased in recent years, with 17 issued in 2012. The majority have been detained for less than 4 years. I wish to emphasize and assure members that prosecuting offenders is and will always be the first and preferred course of action. However, this may not be possible in every instance, as I've explained with examples, especially in cases where witnesses who may be victims or fellow syndicate members are unwilling to come forward and testify in open court. The Act is used as a last resort in such circumstances. Madam, allow me to now elaborate on another important aspect of the CLTPA, the safeguards. Substantial safeguards have been incorporated in the Act and built into the administrative procedures that govern the use of the Act. We have a deliberate and systematic process in place with multiple levels of checks and balances at every stage. First, every case proposed by the enforcement agencies for action under the Act is scrutinized by senior officials from the Ministry of Home Affairs. The public prosecutor also has to agree that the case be dealt with under the Act, and his consent is required before an order is issued by the Minister for Home Affairs. Second, the cases are heard and reviewed by independent advisory committees. These comprise prominent private citizens, including justices of the peace, former High Court and District Court judges, and senior lawyers. The criminal law hearing committees scrutinize the investigation reports and documentary evidence and may examine detainees, investigating officers, and witnesses. Detainees have the opportunity to present their case to the committee and to be represented by legal counsel. The hearing committee subsequently makes its recommendations to the President, who acts on the advice of Cabinet in deciding whether to confirm, vary, or cancel the order. Every detention order is reviewed annually by a separate criminal law review committee. This is to ensure independent decision-making. In addition, any case of detention that might extend beyond 10 years is reviewed and scrutinized by yet another separate criminal law review board. Recommendations to extend detention for a further 12-month period must also be approved by the President, acting on the advice of the Cabinet. Madam, seeking parliamentary approval every 5 years to extend the CLTPA is also an important safeguard. In doing so, the Minister has to account to members for the nature and extent of the use of the powers under the Act and its continuing need amid the prevailing circumstances. Madam, it is important that members of this House, and indeed all Singaporeans, recognize that we cannot afford to take our safety and security for granted. I have spoken at length on the various criminal elements that continue to target Singapore and pose a threat to the safety and security of our people. We have managed to mitigate these threats with the support of the community and the vigilance of our law enforcement agencies and the range of enforcement powers that they can avail. Prosecution in court is the first and preferred course of action against any offender. However, the CLTPA remains an essential component of our law enforcement effort. Robust safeguards and checks and balances have been built into the Act and the administrative processes that give it effect. And these safeguards are applied assiduously and meticulously. The powers under the CLTPA will continue to be exercised judiciously in the interests of public safety, peace, and good order. Madam, I beg to move.